We are NCA's guys.
Okay, so thank you guys for joining my class today. My name is Idayat Balogun. I will be your criminal law tutor. I'm excited to be here with you guys. I love tutoring criminal law, and you can tell from the excitement in my voice. We're going to have a great time in this class. You're going to have a good understanding of the overview of the course. And then when we start the intensive classes, you're going to gain deep understanding into the course that will lead to you not just passing your exams, but actually knowing the course for the purpose of practicing criminal law in Canada, if that's what you choose. I am a legal practitioner in Canada, active member of the Law Society of Alberta. I work as a Crown prosecutor with the Alberta Crown Prosecution Service. Prior to now, I was a defense lawyer while I was articling. So what I bring to the class for you is the good theoretical as well as practical aspect of the course that I hope you will enjoy passing your exams and then using it to practice law in Canada. So what I'm going to do, as I've always done, is to touch base on your materials. You know, the very first step you want to understand is, what do I need to study? What do I need? What materials do I need to read? Now, if you go through your syllabus, which of course we're still using the November 2020 syllabus, NCA has been kind to leave that syllabus as it is. They've not touched it at all. So we're still using that. From your syllabus, you will note that you have two great textbooks that have been recommended for you, which is the Criminal Law by Kent Roach, and then Criminal Procedure by Stephen Cullen, right? Because criminal law is divided into two parts. One is the law and two is the procedure. So we have two textbooks for this, two different parts. Very important, you can't even deal without this at all, is your criminal code. As a matter of fact, NCA has emphasized in the syllabus that you should not just have the most recent criminal code, they recommend the annotated version of it. So the annotated version has some sort of explanation as to the content or the laws in the criminal code. So it gives you more understanding. Sometimes, like I've had my students say, when they get stuck in the exam, not understanding a particular provision, the annotated portion of the code sort of help them to gain better clarity. So yes, you should not just have the most recent criminal code, you should have the annotated version. So now that we've taken those out of the way, which are like the primary tests that you need for the course, I know, like many of my students had confessed to me, they say to me, ID, I do not, by the way, you can call me ID, most of my friends call me ID. I cannot read the textbooks. I don't have time to read the textbooks. I just want to pass these exams and I want some abridged version of the textbook. Okay, I said to them, that's fine. There are some great guys out there who are taking their time to sort of condense the textbooks. So you have some notes out there. What NCA guys recommend is the Manuel Akinshola note. But by all means, if you feel comfortable with other notes, please go for it. Whatever notes you decide to read, you could actually start with one or two, and then you try to see which one works for you. But what I always say to my students is, a month to the exams, please don't try to change your notes. Whatever note you find that you're comfortable with, stick to it and take it to the exams. What I can also say to you is that in my class, I've taken my time to summarize. My students tell me, ID, just condense this your summaries into a note, but I've not had time to do that yet. What I have is chapter by chapter summary of all the chapters in the syllabus. So I would always give that to you some days to the class. So say this week we are treating chapter 1 to 5. I front load chapter 1 to 5 to you. I give that to you ahead of time. You read it, you come to class, you get clearer understanding. And I do that as we go. So I have chapter by chapter summary of all the content of the syllabus. So I can always give that to you as well. That helps. Another great arsenal in my covers is what I call my answer framework. I've put together this answer framework, And I find that it is the most useful part of all the materials I have. Because if you go on YouTube and you read the reviews about the framework, somebody had even called it answer framework from heaven. They've called it several things. Why? Because it worked for them. So what the answer framework actually helps you to do is to give you a framework of how your answer should be put down in your exams, right? And it gives you some content as well. So because you know, the principle does not change. The law does not change. It is the way it is. So if you read the framework, you know the law. For example, you get a question on murder. You've been asked to review a question on murder. You simply pick up the answer framework and you basically put down the principles relating to how you can defend or prosecute murder, how you can establish the element of the offenses of murder. What you will have to be doing in your exams is then relating the framework, meaning the principle, to the fact pattern that you get in your question. So it makes it easy for you to put down your answers. So that framework is also available for you as well, but at a cost. I'll take a pause now to welcome Olusesan. Olusesan, how are you today? Good morning. From my hand, I don't know what part of the world you are. Can you hear me?
Yes, good morning or good evening from here in Nigeria.
Oh, yeah?
Good to see yes, thank you very much.
That's my brother from Nigeria. Can you put on your video?
Okay, let me just do that quickly. Yes.
Yes.
Good to
So
see
I
you.
can
Thank you
see you. Yeah, good to see you. Is it
Thank
okay
you
to
very much.
ask how is Nigeria doing tonight?
Well, Nigeria is the same way the news you read is not far from it, but we thank God for life.
Thank you. I feel you. I feel you from Nigeria, you know. Thank you.
Absolutely.
Please, I will implore you to keep your videos on. I do better when I see faces when I talk, okay? So
Okay.
we've just touched based on the materials that you need to study, and I hope you caught up on all of that. If you do not, you can always get this recording after the class and you can catch up on what you've missed. So we've sorted the materials. Now let's go into the course. For criminal law, yes, for criminal law, what NCA needs you to do in your exam for you to pass, right? You need to know exactly what needs to be done. Criminal law is essentially the body of law that relates to crime. It's basically just, you know, prescribes conducts perceived as threatening to property and life and all of that. And then it sort of criminalizes them and gives punishment for them. That way we can have law and order. That is exactly what criminal law is about, right? So now for you to pass the exams, what do you need to know? You need to know and have the ability to identify the relevant issues. When you get a question, what is the issue? You get your issue directly from the question that is being asked. NCA has a way of giving you the questions like a fact pattern, and at the end of it, or the last line of the question, they give you or ask you the specific question they want. So now your ability to know exactly what you've been asked is very crucial. So you give a fact pattern, they ask you, for example, can the accused person be convicted? What are the defenses available in this? So you need to streamline your answer to that point only. So you must have the ability to deduce the relevant legal issues in the question that you have. That's one. Number two is that you must have the ability to apply the applicable principles of law, right? And the elements of an offense, which is the thesis of the criminal law. What exactly is the element of a particular offense? You must have that ability, you know, and that's one of the things you're going to learn in the class, and I will try to brush through it right now. When you're trying to identify the element of an offense in criminal law, is basically two, actus reus, mens rea. But how do you know the particular actus reus in a particular offense? How do you know the particular mens rea in a particular offense? You do not know that. You can only tell that from the law itself. So what we do in my class is we'll review a particular section of the criminal code, and then we try to understand the actus reus and mens rea of that particular offense, such that if you get any question or any section of the law in your exams, you're already used to interpreting the law and you're able to quickly figure out the actus reus and mens rea. This, I tell you, is the most crucial part of the point, of course. But we'll get into that, and I trust you're not going to have any issue identifying this element of the offense in your exam. Trust me on that one. The third we must learn and get used to is understanding the applicable burden of proof. You all are familiar with these terms. the burden of proof, who must prove a particular point to the court? Who has the honors? Who has the burden, let me use the word, to prove a particular thing in court? So what you must know is that criminal law is also very, what's the word? You cannot treat criminal law without understanding your charter, the Canadian Charter of Rights and Freedoms. And this charter is sort of giving you some rights under the Canadian law. So you have your rights, and the government must not infringe on these rights when they are crafting their criminal laws, right? So because of that, you must understand that there is a presumption of innocence in the charter. And simply because of that presumption of innocence, the burden to prove the essential elements of an offense lies with the Crown, just because of that presumption. And how that presumption works is, it just basically tell you who goes first in court. We all have been to court, right? You know, when you go to court, if you're the plaintiff, if you're the defense, if you're the plaintiff, you're the one starting because you're the one wanting the court to give you a particular order or a particular judgment. You go first. So in the same way, in Canada, the police would usually be the one to draft the charges. And then when the Crown prosecutors go to courts, they would have to prove beyond reasonable doubt that you committed that offense. As a matter of fact, I found working as a defense counsel easier than working as a prosecutor. Because as a defense lawyer, I just go to court and fold my hands and I'm looking at the Crown. Okay, go ahead. You brought me to court, prove this charge. And then they will struggle and try to, now that I work as a Crown as well, I know that's the toughest part of it, you know? So you go to court, you just fold your hands. Why? Because the Constitution, the Canadian Charter of Rights and Freedom, says everybody is presumed innocent. So the prosecutor would have to go to court to say, oh, my Lord, Your Honor, this guy before you today has committed this offense. How? He did this, actus reus, intending to do this, mens rea, and by so doing, he's committed this offense under the law, and I'm asking the court to convict him or her. So once the prosecutor does that, he's proven that burden beyond reasonable doubt. I always say beyond reasonable doubt, and I always like to explain it. It is beyond reasonable doubt, not beyond any shadow of doubt. Meaning that once the jury, will get to that as well, or the judge reasonably believe that the accused commit the offense, they can convict. But it must be a reasonable belief, right? Now, once the prosecutor has done that, what NCA also expects you to understand is that sometimes this burden actually shifts. Because once the prosecutor is done presenting their evidence and doing everything, they go down to the seat and then they sit down and fold their hands. Whose turn is it? It's the turn of the defense counsel to then stand up to say, what? Your Honor, my Lord, all the evidence, like we always do, I always do that. All the evidence that the prosecutor had tendered before the court is inconsequential in this defense, in this case. It's not admissible. It is not, I'll say all the grammar I want to say. Why? Because I want to puncture the case of the prosecutor to say, you've not discharged the burden under the law. You've not done what the law says you must do. You've not proven this offense beyond reasonable doubt. That is always what defense lawyers will say. When I stand up and I say that, I'm saying that's why, because the burden had now shifted to me. So that burden of proof that was on the prosecutor had been discharged, and now it was my turn to take on the burden to then try to prove to the court that the accused person did not commit the offense. If I fail to do that, the accused gets convicted. If I succeed in doing that, the accused gets acquitted. So you need to know how that burden of proof shifts. So how would you see this in your exam? You'll probably see this when you get a question around offense section. NCA will give you a question about, from the criminal code, they give you a question, and then they'll tell you, can the accused person be convicted? When NCA is asking you, can the accused person be convicted, they are asking you to prove the element of the offense. You are taking the position as a Crown counsel. So you go do your actus reus, mens rea, do all your arguments. We'll talk about all of that in my class, so don't stress about that right now. That is you taking on the burden as a Crown. When will you take on the burden as a defense counsel? when NCA is asking you, is there any available defense? Is there any available defense for the accused person? You are taking on the role as a defense counsel. You need to then puncture the case of the crown. So knowing where the burden lies and how it shifts is everything for your NCA exams as well, right? So that's 3, right? You also then need to have the ability to, give me a sec. So when you then identify the rules, when you identify the principle, this is where students also struggle. You know the rule, you know the principle, but you are not able to apply that to the fact pattern that you have, to the fact that NCA are giving you. So we must also get the skill of not just knowing the law, but applying it to the facts of your questions. So NCA will give you fact pattern questions. Somebody went to a store, bubbled into the store, shouted on the attendants, went away with XYZ money, and when they were trying to arrest him, he was trying to evade the arrest. They give you all these stories. You know that under the criminal code, you should not commit an assault. Under the criminal code, you should not steal. You know the law. You've seen the facts. How do you marry together? NCA want to see you connecting that. That's one of the things you also get from the class. You must be able to apply the law to the facts in your question, right? The answer framework also help you with all of this. So please don't stress. I want you to relax. I can see from your faces, I don't know, am I overwhelming you guys already? Please, it's nothing. It's going to be like easy peasy, like my son will say. Mom, is going to be easy peasy. Okay, so please, let's just relax. And then the last thing we must also learn is the ability to conclude logically. Now you've done the great job as a crown counsel or as a defense lawyer. You've identified the issue, you've identified the law, you've related the law to the issue, to the facts. What's your conclusion? What do you want to take away from everything? So you must be able to conclude. For your criminal law purpose, your conclusion mostly, depending on the question, is, oh, yes, the accused can be convicted. Oh, the accused cannot be convicted. Yes, this defense can work. No, this defense would not work. That's your conclusion. But your conclusion must be logical. How? Because it must flow from the argument that you've done, right? So that ability to conclude logically is also very important. And you will also gain that expertise in my class. One thing I can tell you is, and as you all will agree with me, actually, being lawyers that you have, NCA is not particular about your conclusion. When you say, oh, the accused can be convicted, or no, the accused cannot be concluded, I want to say it simply, NCA doesn't care. All they want to see is that your conclusion flow logically from your arguments. Because as lawyers, we all can have different arguments, you know. I can go to court and say, oh, the accused can be convicted. Sheson can go to court and say, oh, the accused cannot be convicted. And then he backs it up with his own argument. Do our thing, our advocacy, argue our law. We have different conclusions, but we've identified the same issues. We've related it with the same law. We've applied the same law to the same facts, but we have different conclusions. That's why we are lawyers. Our ability to convince people or argue conclusively that this is not the position that I see is what makes us lawyers. So NCA can relate to that. NCA understands that. But they must see that you understand the issue in the question. One thing NCA had also said categorically is that you must not demonstrate confusion. Sometimes the law can be confusing when you're trying to analyze it and you just say, oh, it is this, oh, it is that, you're not sure. When you answer your questions that way, NCA could tell, an examiner can tell that this candidate was confused in the analysis. And the moment they sense confusion, once you have confusion in analysis, you can't even have a logical conclusion, right? So that means something is wrong. So we're going to try and make sure that you don't have that confusion in your exams. And this, I can tell you, like I've been boasting before other people join the class that I've recorded 100% pass in all my classes. None of my students had failed. So I'm positive you all, and none of you would put that record, right? I'll take a pause now to welcome Tolu and B. Tolu and B, good morning from my end. Can you guys hear me?
Good morning. Thank you. I can hear you very clearly.
Thank
Hi,
you,
good
B.
morning.
Tolu? Yes.
Sorry, that was Tolu that spoke.
Oh, my bad. I'm sorry.
Not a
And
problem.
now this
No,
is,
this is B.
okay.
Good
Hi, B.
morning.
How are you? Good
I'm
morning.
great, thank you. How are you?
I'm okay. I think I'm surviving. Are you enjoying the class so far?
Oh, yes, absolutely.
Yes,
Thank
I
you.
am.
Are you able to put on your videos though? I want this class to be like a mini family group.
Can I open it after a short period? Not right
Okay,
now?
sure.
Yeah.
Okay. How about Tolu?
I'll try to put it on. I just got the link for the meeting, so I wasn't even prepared to actually attend.
Okay, I'll give you some time. I
All
would
right,
like
thank
to
you.
see your faces. That way I'm able to give you as much energy as I can.
All right.
Okay, so let's start. What we're going to do, introducing this course to you all, is to try to go through the syllabus. The syllabus, we have 32 chapters. Can you all hear me? Okay. I kind of feel like
Yes.
I was frozen a bit. Okay, we have 32 chapters in the syllabus. These 32 chapters, I can conveniently break it down into 5 parts. So we have the offences part, we have the defences part, we have the procedural part, we have sentencing, and then we have police powers. You see these 5 things I've mentioned, you will get questions on all of this, one way or the other. Sometimes NCA will give you short questions, 5 marks kind of question, but they try to cut across these different parts I've mentioned. And we'll cover all of this in class, actually. So for the offenses, let's start with that. What you need to understand about the offenses is, 1, you must understand the sources of law, which is the first chapter in your syllabus. I will try not to do chapter by chapter because I think that would take our time. But for the offenses part, you need to know that there must be a legislation criminalizing a particular conduct. If there was none, you cannot have a criminal offense. Does this make sense? Why? Which is why your source of criminal law is your statutes. And the major statute we're talking about here that you will be dealing with in your exams is the Criminal Code of Canada. The Criminal Code contains all of the offense questions, let me not say all, most of the offense questions, sections in Canada. We then have other statutes, like some statutes focused on the particular offense, like the Controlled Drugs and Substances Act. That act is there, enacted by the Parliament. Why? Because it wants to correct a particular offense or issue that is a problem in the society. So they will specifically draft a law focusing on the particular conduct. So you would have that, right? So your major source of your criminal law is your criminal code. You could have other statutes as Parliament feels necessary to enact, right? So you have that as an example, Controlled Drugs and Substances Act, right? So with that, your criminal code, your source of criminal law must be a statute, a legislation by the Parliament. Only the Parliament, I don't know, any of you don't quit constitutional law yet? This is not a constitutional law class, but we do a bit of cons law too. Only the Parliament, under section 91 and 92 of the Constitution, have the power to enact criminal law provision. You know, Canada is also practice federalism and all of that. Power is vested in the federal government as well as in the provincial government. But in dividing the power between these arms of government, you know that only the Parliament, which is the federal government, can enact criminal law provisions, right? So meaning that all your criminal code is from the Parliament. It is the primary source of your criminal code. And it must be written. You know, when they say criminal law must be clear, concise, and not ambiguous. An accused person have the right to know ahead of time that a particular conduct is a criminal conduct so as to avoid committing it. If your criminal law is not written, I would not be able to prevent or stop myself from committing a particular offense. Why? Because I'm not aware of it. So it is the same reason why you cannot have common law as a source of criminal law. Common law, we all know, is just unwritten law, right? That comes from judges' practice and all of that. It's not written, right? So even though it's a source of law, it cannot be a source of criminal law, because criminal law must be written, must be clear, must be concise, and must predate the offense itself. Like, it must be in existence prior to you committing that particular act. If there was anything that you did, an offense that you committed, let's say you committed an offense today, and then the Crown goes to court to say, oh, there is a law enacted on December 13, 2021, and you committed your offense December 11, 2021, something like that. The defense counsel will stand up to say, oh, my lord, the accused cannot be charged for that offense. Why? Because the offense predated the law. So it should be the other way around. Why? Because the accused needs to be put on notice to act accordingly to the law, right? So that's one reason that your common law cannot be a source of criminal. I always tell my students, and try to relate this to how this would impact, or how you could see this in your exam. So for example, when NCA gives you a question and they says to you, oh, the accused has been charged for committing an offense under common law, can the accused person be convicted? From what I'm telling you right now, you know straight up that the accused cannot be convicted or even charged under an offense under common law. So which is why the NCA would always give you the particular section of the offense they want you to interpret or analyze in the exam. It would most likely come from the criminal code. With experience, I've not seen any question from the NCA on offenses that was outside the criminal code. I know we have other statutes like the Control and Drug and Substance Act, like I mentioned, but I think NCA is pretty much focused on the criminal code. So it would be fair to say that you should expect your offense questions to come from your criminal code, right? So that way, at least we can begin to streamline our thought, right? NCA will give you the section of that particular law, and then you can review it in your criminal code. Now, I know I've told you all now that common law cannot be a source of criminal law, but common law can be a source of your defenses. So you can have defenses under the common law. Common law, an example of a defense you have under common law is entrapment. We'll get to that. Entrapment is basically a defense that an accused can come up to say, oh, my lord, I was entrapped to commit this offense by the police. Common law is a law that sort of ameliorates the harsh effects of the law itself, right? You know, when the police investigate an offense, they do it with passion. They do it so much that they want to get evidence to prosecute you. Common law is telling the police, be careful when you do that. Be careful, don't trample on people's rights, which is where the defense of entrapment comes in. You know, police, most likely this defense, you find it mostly under drugs trafficking, when the police would often act as undercovers. You know, they do it so well, they play a role. Sometimes they act as the addicts, you know, just to get to, you know, investigate a crime. And sometimes they do it so much that they sort of lure the accused person to commit the offense. Now, when they do that, it's an acceptable technique, don't get me wrong, and you will get this clarity when we treat the defense of entrapment. It's an acceptable technique, but there are rules and guidelines. The police simply must not do it too much. They must not do it too much such that it is just by their conduct that had made the accused commit the offense. If it's that way, then as a defense counsel, you go to court and scream, entrapment, my client was entrapped. That way the court will consider that defense. That is a common law defense. So you will not have common law as a source of criminal law, but you will have common law as a source of defense. Does this make sense? You can also have common law. Common law has also been used to interpret criminal law offenses. For example, I'll give you the case. Tolu, your hand is up.
Sorry, I was looking at the syllabus, and it says here that with the exception of contempt of courts, criminal offenses are created in Canada by statutes.
Yes.
So basically, based on what you have said, common law cannot create offenses. However, the offense of contempt of court is a common law offense.
Yes, it is.
All right.
Yes. Thank you, Tolu, for pointing that out. So it's just for the exemption of contempt. And we all know what contempt is, right? When you go to court, you misdirect or misbehave or do anything, disrespectful to the court can cite you in contempt. So there is no law written for that contempt. It was derived as a result of judges, interpretation. So yes, with the exemption of contempt of court, right? I like that Tolu is following me with the syllabus. So that's one great thing you should note. With my experience as well, you will not get a question on contempt. So, which probably explains why I didn't think to bring it up right now, since we are just touching on the surface, right? So you will not get a question on contempt. You will get a question from the criminal code, right? And you will do yourself well to know that understanding to respect questions from the criminal code and knowing how to interpret the criminal code. You will get that understanding in my class, I can assure you as we go. So now, I was saying that common law can also be used to interpret criminal law offenses. And I'll give you a quick example. From your syllabus, NCR cited the case of Aaron Jobidon. And what it's basically saying is, for an offense of assault, for example, one acceptable defense for assault is that the victim consented to the assault. Is a defense. You can go to court and say, oh, you can't charge me for assault because the victim agreed that I assaulted him or her. The court will listen to that defense. But in the case of Aaron Jobidon, the court is also saying that no man can consent to the infliction of grievous bodily harm. No man. So what that means is that when you're raising your defense of consent, you will do yourself well to know that if you've inflicted so much harm on me, I cannot reasonably, I don't think, unless any of you here on this call would be happy for somebody inflicting grievous bodily harm on them. Once the harm goes beyond the minimum, the court begins to interpret the level of harm. How much consent can a man give to infliction of harm? When you begin to hurt me so much that I begin to bleed, common law expects you to stop even though I gave you consent to hurt me. When you don't stop and you want to go to court to say he or she consented, the Crown will say, no man can consent to the infliction of grievous bodily harm, and they will proudly cite the case of Aaron Jobidon, and the court will have to listen. So that's one way that common law has been used to interpret criminal law provision. Does this make sense to you guys? Yeah? Do you have any question on that? I've basically just touched on chapter 1 of the syllabus. And that's essentially all you need to know, honestly, for your exams. I try not to oversimplify things, but things can actually be simple. You don't really, I just give you clear understanding and then focus on what you need to pass your exam. With what I've said, unless I'm wrong, I'm sure everyone on this call right now understand that you can only have your source of law from the criminal code. You can't have it from common law. However, which is the summary of everything I've said. However, your common law can be a source of defenses, and your common law can also be used to interpret criminal law provisions. And that's essentially what you need to know for chapter 1. Do we have any question on that? Does it make sense? It does, right? So that's it. So let's move to chapter 2. And I hope we can do as much. If we, anywhere we stop, will be good. You guys will get the gist in the intensive class. Chapter 2, power to create criminal law offenses and criminal law procedure. I think I mentioned it already. Here we are just basically focusing on division of power between the parliament and the legislature. That's the provincial government. Who has the power to do what? I should tell you immediately that apart from criminal law offenses, we also have regulatory offenses, right? The regulatory offenses will be beating the traffic, for example, dumping refuse, for example. You know, those are examples of regulatory offenses. Who would have the power to enact such offenses? I can tell you it's both the parliament and the legislature. Both of them can enact laws relating to regulatory offenses. However, you're not going to see any regulatory offenses in your criminal code, even though it is enacted by the parliament. Tolu, your hand is up.
I'm sorry, I hope I'm not taking you back, but I'm just trying to understand the difference between parliament and legislature.
Thank you. I'll explain it. Because Canada practices some sort of federalism as well, there is power vested. When we say the parliament, we're talking about the federal government. Can I put it that way? The parliament is the federal government. The legislature is the provincial government, right? So now, because we are dealing with different arms of government, the Constitution was great enough to enact what we call the division of powers. So they've divided these powers between the federal government and the provincial government. And in this class, I'll mention it as parliament and legislature, because that's the term we use in Canada, okay? So parliament and legislature, they've divided the powers between them, right? So now, who has the power to enact criminal law offenses? Only the parliament can enact criminal law offenses, only the parliament. But then we have regulatory offenses. Who has the power to enact regulatory offenses? I'm telling you that it is both the parliament and the legislature. Does this make sense? Are you following me so far? Because I'm about to say something that may sort of confuse you. Now, if you follow me carefully, you will note that in this class, I've mentioned that all your criminal offenses, most of it are contained in the criminal code. When we leave the criminal law realm and we go into the regulatory field, different principles apply. We'll get to that as well, right? But suffice to know that even though the parliament has the power to enact regulatory offenses, you will not find those laws in the criminal code. Why? Because they are not criminal laws. They are regulatory laws. So you have other enactments for that, other laws. And let me calm you. When NCA gives you a question that is a regulatory offense question, they will provide you the particular law in your exam. It will be outside of the criminal code. In fact, when my student asks me, ID, how can I tell the difference between a criminal law offenses and a regulatory offenses in the exams? I say to him or her, one way to quickly know that is when NCA has given you another law outside the criminal code. Then you know that most likely you are dealing with a regulatory offense, most likely. Right? That's one way to know. So now when we talk about regulatory offenses, there's a chapter in your syllabus on regulatory offenses. When we get to that, we will discuss the applicable principles in regulatory offenses. For now, I want you to know that the principles applicable to criminal law offenses are different, completely different from the principles that are applicable to regulatory law offenses. We'll get to that very well, but this is just a background. So, summary of this chapter. I always tell my students to do the summary of all the chapters I treat. Who want to do the summary of this one for me? How to create criminal law offenses, who can create criminal law offenses, who can create regulatory law offenses. One more thing I missed, power to create the procedural law. So even though the parliament is the one creating the criminal law offenses, the provincial government have the power to create the procedural laws. For example, when we talk about appointment of juries, you know, how to form the jury panel, what are the laws? Those are made by the provincial government. Do you see? So the criminal law is for the parliament, the procedure is for the provincial government, right? But when we talk about the procedure in trial, how does the trial proceed? what are the, evidential laws and all of that, those ones also lie with the parliament. Am I making sense? Am I confusing anybody? Tolu, you are squeezing your eyes. I see you squeezing it like, oh, what the hell did she just say? Do you have any question?
No, I was just trying to take it in because I thought the implementation of courts of the criminal proceedings is handled by the province.
Yes, you're correct.
Okay, so implementation is handled by the province, but the procedure for criminal proceedings is laid down by parliament. Okay.
Yes,
right.
and I'll quickly explain how that is so. If you go into how the courts are created, I don't want to go deep in this class because it's introductory. If you go into how courts are created, you will find that most of the criminal law offenses are prosecuted in the provincial courts. That's like the first level of courts. And it is the provincial government that have the power to regulate the procedures in that courts, in the provincial courts. So which makes sense that it is provincial government that will tell you how to appoint a jury, how to form a jury panel and all of that. We'll get there. But to summarize what I've said, parliament have the power to create criminal law offenses. One, parliament and provincial government have the power to create regulatory offenses. Parliament have the power to enact procedural laws relating to trial. Provincial governments have the power to regulate procedural laws relating to criminal procedures. I don't know how this sounds, but that's how I can break it down for you to know that different governments is doing different things, right? But for the purpose of your NCA, what I've seen mostly happen is you need to just know that parliament is the one that will create these criminal law offenses. And both the parliament and the provincial government can enact your regulatory offenses. So because when you get the question, because this is another question I get a lot. My students will say, oh, ID, you've just said it is the parliament and the provincial government that can enact regulatory offenses. How can I tell in the exam that a particular regulatory law offense was enacted by parliament or by provincial legislature? I tell them from the name of the law that you've been given. If they say XYZ, you know you're dealing with parliament. If you say XYZ law, it ends with law, the name of the offense ends with law, you know you're dealing with the provincial government. But be that as it may, the same principle applies. Tolu, you see why you must always turn on your video? I see when our face goes that way, like, oh. Do you have a question? Are you good?
Sometimes I think I do my face like that when I'm trying to is it compartmentalize what you have said so that I understand what's there. So.
I know, it's okay, but are you good? It's
Yes,
going to be
good.
clearer in the actual class. Remember, this is just introductory. This is just to open your mind to what you should expect to read in your exams, in your course materials. So that when you're reading your actual notes, you say, oh, my students say, ID, we hear your voice in our head. You know, when you hear my voice, oh, ID said this. Oh, that is why it is this. So this is just to help you sort of relate with the content more. It's not by any way meant to clarify everything because we can't achieve that, okay? Yeah?
Thank you.
So now, that's your power to create criminal law offenses. I'll say one thing before I leave this topic. How do you identify a criminal law offense? What are those things that must be there for you to say, oh, this is a criminal law offense? This has been stated in the case of Aramamo Levine. Yeah, I'm glad I still remember my cases. Aramamo Levine says to you that a criminal law offense must have, before I say this, have a disclosure to make. The person sitting before you have a problem with pronouncing a particular letter in the alphabet. I cannot, I've tried, but I've failed to pronounce the letter R. Did I pronounce it well just now? The letter R, I struggle with it. I can't seem to get it right. My son had tried, we've had sessions, my husband has tried, everyone tried. people make jest of me now. So what I do is before you begin to make jest of me, I will tell you ahead of time. So please, I'm about to say something with that letter. So please, when you laugh, please laugh with kindness, with a bit of kindness, okay? So Alamamo Levi says that for you to say that a particular law or offense is a criminal law offense, it must have 3 P's. 1, prohibition. It's whatever conduct it is, it must be prohibited by a particular law. That's 1. 2, it must have a public purpose. What exactly is the parliament trying to achieve by enacting that law? What is the purpose of that law? You must see that public purpose in it. And 3, it must have a penalty. So there must be penalty. Those are the 3 P's. And I think I'm doing well with my house today. Those are the 3 P's that you find in your criminal law, right? So that way you know that you're dealing with a criminal law provision. I think that sums up chapter 2. And if anybody want to do a recap, I would love that because it helps me to note that you're following. Who wants to do the recap? Who would do us the honors of doing the recap? Puneet, where are you? My inspiration is gone because your video is gone. B, are you still making up your mind whether for us to see your face? Please, guys. Tolu, do the summary. You can do it.
My camera is on, but it's just that I'm also taking notes on my phone. So when I go take notes, the camera goes off.
Oh no, so what do we do? Because I love seeing your face.
Maybe I'll look for a pen and paper and make my notes.
Thank you. There you go. Thank you. Tolu, sum it up.
Okay.
Powers to create criminal offenses and criminal law procedure.
So power to create criminal offenses lies with the parliament, that's the federal government, and the power to also make regulatory offenses lies with both parliament and legislature.
Good.
The procedures for criminal law trials is created by parliaments.
That's correct.
Yes, by parliament. But criminal law offenses are tried in provincial courts, and the procedures of the provincial courts is created by legislature. Sorry,
I would say clap for Tolu.
I'm flipping
I would say
because I
clap for
wrote.
Tolu if we were in the elementary school. Thank you, Tolu. That is great. That is great. So let's move. Let's look into another very important law that I've talked about already, but I'll mention it one more time. It is the Charter, the Canadian Charter of Rights and Freedom. What is the importance of this law in criminal law? You know, as we all know, the parliament will create laws. When they create the law, their own focus is just to bring law and order in the community. That's what they do. So when they enact laws, they tend to sometimes infringe on some rights, you know. And what the Charter would do, the Charter acts as the watchdog to caution the federal government, the parliament, as to what to do when they're enacting these laws. So when they're enacting the laws, the parliament is also being careful. Oh, the Charter is there to come and pull me down if I don't do it right, that kind of thing. So that's the importance of the Charter. And there are 2 important sections in the Charter for you. Section 52 and Section 24 of the Charter. Very important 2 sections. Let's start with Section 52. Section 52 is applicable to the law. What do I mean by this? When the parliament in their good wisdom enact a law that contravenes the Constitution. Remember, your Charter is part of the Constitution. If you've seen the Constitution of Canada, the Constitution is not actually in a book. It's written everywhere. and the charter is part of the Constitution, right? Criminal laws must comply with constitutional values. Section 52 of the charter is telling you that any criminal law that fails to comply with the constitutional values, aka also known as the charter rights, will be struck down. So it says you can either strike it down, or you can sever the particular section, or you can suspend the applicability. There are quite a number of options under Section 52. But what I'm saying essentially is that if there is any law that's failed to comply with the charter, that law may be struck down, may be severed, part of it may be severed, it may be suspended. The court can make pronouncement as to what to do with that law. But what we know is that that law cannot stand as it is because it violates the charter. Make sense? So once you have a question around, in my experience as well, I don't see much of this in your exams, but since I'm not the NCA, once you see questions around the validity, this is more like a question for constitutional law, not criminal law, but it's for you to know that what remedy would an accused person have when they say that a particular law has infringed on their rights. So you come to Section 52, and then you come to Section 24 of the Charter. That's where their remedy lies, right? But different principles also apply to Section 52. For example, if the law particularly affects the person, the court may not be able to strike down the law. That's a conversation for constitutional law class. The one that's mostly applicable for criminal law is Section 24 of the Charter. Section 24 is focused on the conduct of the authorities, mostly the police. When the police is investigating a crime, and maybe they needed to search your house, search your car, or whatever, they must done it in accordance to the charter. We'll get to that. There is the police power section in your syllabus as well, where we review your Section 8, your rights against unreasonable search and seizure, your Section 9, your right against arbitrary detention, and Section 10, your right to counsel in the course of investigation and in the course of prosecution. When we get there, this part will be clearer. But what I'm saying now is, when the police in the course of investigating infringe of any of these rights that I just mentioned, what remedy would you have as an accused person? That remedy is contained in Section 24. It says that, and the most important part of it is contained in Section 24 sub 2, that talks about the exclusion of evidence. And the summary of it is this: when the police in the course of investigation infringe on your rights to get a particular evidence to go to court, when you, as the accused person, succeed in telling the court that in the course of investigation, the police actually infringed on my right, then you ask the court for a remedy. You know, that thing we say, I'm not sure, the laximism, ibi jus, ibi remedium. When there is a wrong, there is a remedy. The moment you are able to establish that wrong, then the remedy must follow. So if the court agrees that police officer had infringed on your right, then they must grant you a remedy. What's that remedy? You will tell the court that all the evidence that the police got in the course of investigating you and doing it wrongfully, that you would want the court to exclude that evidence in the proceeding. That is one remedy you can get. So when you have a question around charter rights in your criminal law, it's most likely on what remedy your accused can get when Section 8 or Section 9 or Section 10 of the charter had been infringed upon by the police or by the Crown. In that case, the court will say, it will not be fair for us to allow the evidence that the police got wrongfully and still use that evidence to convict you when we've agreed that they infringed on your right. It would not be just. So in that situation, the court can grant you a remedy of what we call exclusion of evidence. And you'll find that the moment the most important part of the Crown's case, the most important evidence has been excluded, the case actually collapses. So it will not lead to a conviction. So that's the importance of this, Section 24 substitute. Does this make sense? There are quite a number of cases under this. One I will try to quickly talk about is the case of Canada and Bedford. This case of Canada and Bedford is AKA with prostitution reference. It's just a case of some prostitutes who went to court saying certain sections of the criminal law infringed on their right to practice their prostitution. Believe it or not, the court agreed with them. And part of that section 210, 211, and 213, if I'm not mistaken, of the CC, were the sections that it challenged. Why? Because section 210, if I'm also not mistaken right now, and I think I'm not, section 210 says that you cannot keep a body house. Now, you tell me I have a right to practice or trade in whatever business I want. And then you tell me I cannot keep a body house. So where do I stay when I'm practicing my prostitution? That's what that's what they told the court. Where do we stay? That this law exposes us to danger. Because if we cannot keep ourselves safe, it means by extension, we are not free to practice our prostitution. And the court agreed. Another section they also challenged is section 212. Oh, I said 211 before. It is 212 of the CC, Criminal Code. It's prevented them from living on the avails of their prostitution. This one is actually very ridiculous. So you allow me to prostitute, but you tell me I cannot live on whatever money I made from the prostitution. So the prostitute went to court and say, with this particular law, I'm not able to pay a bouncer, somebody that can protect me while I practice my trade. As a matter of fact, this law is infringing on my right to free trade. The court also agreed with them. So that's one way. And what remedy did the court use? The court gave them remedy under section 52 that allowed the court to either strike down, sever a particular law, or suspend its application. Do you see how we've related that to an actual case? So that's one example of how you can see it happen. Does this make sense? Make sense or no? Are we good? Can we move on? I have the tendency of wanting to review cases, but it will slow us down. You have very interesting cases in criminal law. I was just thinking about Aaron Oaks right now, and I'm about to talk about it, but I will stop myself. When it comes to the intensive class, we'll talk about the interesting cases, honestly. So, but summary of this is the charter is used to watch or guide the activities or enactment of laws by the federal government or by the parliament. It helps them to conform with the Constitution. Right? Make sense? Okay, so I always tell my students that the first two chapters are just introductory. With chapter 3, which is the procedural classification of offenses, we are then going deep into the end. Procedural classification of offenses. What does this mean? How do you classify offenses in Canada? So what Canada do, just like most countries, is they classify offenses based on their severity. The most severe offenses are classified as indictable offenses. I will explain the word. The less serious ones are called summary offenses or summary convictions. There are two important sections in your criminal code regarding this point. Excuse me. You have your section 553. Section 553 of the criminal code that gives you a list of what we call summary offenses. So you have offenses like theft, obtaining by false pretenses, breach of recognizance, and all of that. They are serious but not so serious offenses. So they are summary offenses, right? Then you have section 469 of the Criminal Code. Those ones have a list of offenses like treason, mutiny, piracy, murder. Those are called indictable offenses. What are the implications of classifying offenses in Canada? What does that mean? Before I go to the implication, I should tell you that we also have what we call hybrid offenses. Hybrid, just like the word mean, like it basically stands in the middle. It is hybrid. It is not summary. It is not indictable. It is just somewhere in the middle. How do you know which offense is summary, which offense is indictable, and which one is hybrid? How do you begin to understand the implication of this? I will simplify this as much as possible. For your summary offenses or indictable offenses, when you read the section of your criminal code, Parliament have actually categorized some offenses as summary or as indictable. For example, it says anybody who commits XYZ commits a summary offense. That way, Parliament is telling the Crown that when you go to court to prosecute this offense, you are adopting a summary approach. They have the power to tell the prosecutor how to do that. If you go into your criminal code as well, you would find some sections that says anybody who commits XYZ commits an indictable offense. What that also means that Parliament is telling the prosecutor that when you go to court, you must prosecute this offense by indictment. Now, there are some offenses that Parliament will also say it's either summary or indictable. They will say things like anybody who commits XYZ offense commits a summary offense or an indictable offense. That is where your hybrid come into play. Because at that point, the implication of that is that the prosecutor will have the discretion to choose which of the mode they want to prosecute the offense. The other instance where you would have hybrid is when the Parliament is silent as to the mode of prosecution. They are not saying it's summary, they are not saying it's indictment, they decided to keep quiet about it. What that means also is that they are giving the prosecutor the discretion to choose how they prosecute this offense. Now, this would make sense to you if you understand the implication of whichever mode the prosecutor has decided to prosecute. I'll list them out because this is a summary class, introductory class. For a summary offense, right, the implication is that, well, for both offenses, it has implication when it comes to the penalty and the procedure to adopt. As a Crown prosecutor, if you commit an offense and you've committed it in a cruel manner, you have several records of previous conviction regarding that offense, the offense is against a child, or the offense is against your partner, I can decide, if the Parliament did not tell me what to do, I can decide to draft an indictment. Why? Because in my professional opinion, the way and manner that offense was committed was so grievous. I would go for an indictment. Does this make sense? And the implication of going for an indictment is because it says a lot on the penalty and the procedure. So there's always know that there's always some balancing between the power of the prosecutor and the rights of the accused. There's always that balance. So as a prosecutor, the penalty for indictment, any indictment, is 2 years and above imprisonment. 2 years and above imprisonment. So what does that mean? It means if I draft an indictment as a prosecutor, which I would have the discretion to decide, the judge cannot question me. We'll talk about prosecutorial discretions later in the class. The judge cannot question why I have decided to go by an indictment. And what I'm essentially telling the judge is that for this particular offense, I want the accused to go to jail for at least 3 years. And the judge will not have any discretion to bring that down. But if I decide to go by summary conviction or summary offense, the penalty for summary offense is always 2 years and below imprisonment. So the moment I decide to file a summary proceeding, it means I'm telling the court that yes, the accused can get 2 years and below imprisonment. So that's one implication of deciding which of the mode to go with. Does this make sense to you guys? Another thing with summary offenses is that it has the statute of limitation of 2 years. If as a prosecutor, and this is one thing a prosecutors always struggle with, if as a prosecutor, somebody has committed an offense and you're deciding, oh, I'm going to prosecute this offense summarily, you must file that charge within 2 years. If you do not file that charge within 2 years, what happens? I'm sure you all know, it becomes statute barred. You can't do it anymore. The accused goes, scot-free. Now, prosecutors always struggle with this. Why? Because sometimes they've communicated that they want to prosecute summarily, but for some reason, they were not able to bring the charge on time. They now want to turn it into an indictment. At that point, the court can say no, procedural fairness, no. Because the major reason you want to change it to indictment is because you don't want to be caught by that statute of limitation. So that's another implication for how you decide to charge, right? Then the procedure. For summary offenses, you cannot have jury trials. In Canada, you could either have a judge alone trial or a jury trial. So when you have a jury trial, most offenses under Section 469 that I mentioned earlier, treason, murder, piracy, all of those big guys, the accused will have the right to a jury trial. They can choose, right? I don't want to go deeper into that. I'll leave that for now. There are more points to note on that one, but I don't want to go deep into those right now. But suffice to say that the accused would have a right to a jury trial for offenses under Section 469 of the Criminal Code. The accused will not have a right to jury trial for offenses under Section 553, which are offenses like theft, all those small guys, So that's another implication for how the Crown decides to charge. Make sense? So how does this affect you for NCA exams? NCA would do this and give you, it's most likely applicable when you are treating the question on sentencing. This is how you classify your offenses. It's mostly seen when you're dealing with sentencing. Why? Because for sentencing, NCA would ask you, what is the available sentence? The accused has been convicted. What sentence can you impose on him or her? You cannot answer that question unless you know the mode of trial that the prosecutor had adopted. If the prosecutor adopted an indictable approach, you know that your sentence cannot be less than 2 years. If the prosecutor adopted a summary approach, then you know that you can have less than 2 years and even have other forms of sentencing like conditional sentence, suspended sentence, community service, all of those small sweet guys. We'll talk about them in class as well. So you must know the procedure that was adopted before you can answer your sentencing question. And most importantly, we'll talk about that when we get to sentencing anyways. But in terms of how this topic affects your exam, it's mostly seen when you're dealing with the case of questions on sentencing. Does that make sense? Okay. Interpreting Criminal Provisions, Chapter 4. Are we good so far? Yeah? Puneet, where are you? My inspiration is gone again. Interpreting Criminal Provisions.
Sorry, I didn't realize it was off.
Thank you for. So how do we interpret criminal provisions? I'll tell you, this is very important for exams. I'll give you this quick gist. My friends and I, when we wrote the criminal law exams, we wrote an assault, and we needed to interpret a word. And I don't want to sound like the good one, but they all just missed that very important point of checking Section 2 of the Criminal Code. And because you've missed that important interpretation, your analysis of that section will be wrong. So it's very important. So I've told us that criminal code, no, I didn't tell you, but I'll tell you now. Criminal code is also divided into parts. So when you open it, you also see part 1, part 2, and all of that. Now, when you want to try to interpret a particular section, how do you interpret it? If you see any ambiguous word, when you read a law or a section, and one word looks to you that this must have more meaning than I think, it's telling you to check how that word has been interpreted. When you come across such words, the very first place you want to check is your section 2 of the criminal code. It has that list of words all through the criminal code that they've interpreted there. So your section 2 in definition section cuts across all of the criminal code. Now, because the criminal code has been divided in parts, you now have some words at the beginning of each part that interpret the words that you find in that particular part. So say you look for section 2 and you couldn't find the word you were looking for, you would go to the beginning of the part of that particular part of the criminal code that you were dealing with. Does this make sense? And then you would then look through it to see if that word has been defined there. Sometimes also, the word you're looking for may have been interpreted in the body of the section itself. So if you read that section and you do not find the meaning in the body, we will do the demonstration in class. I can't go through the criminal code right now. I would have given you vivid examples, but we can't do that because of time. The words would have been described in the particular section that you read. If you didn't find it there, then you go to the section 2, then go to the beginning of the part, and that's how you interpret the criminal law offenses, the words. Now, what are the principles of interpreting? So you have your strict construction. It's a principle. What's your strict construction? It's just a particular interpretation that sort of favors the accused person. And what does this mean? It means that when you're interpreting your criminal law and you find some ambiguity, you're not sure what the law was saying, the accused will take the benefit of that doubt. The interpretation the court will give to you would most likely favor the accused. That is strict construction. But recently, Canada had moved from strict construction to purposive interpretation. Purposive, what does that mean? An interpretation that sort of focuses on the intention of the parliament. What is the parliament trying to achieve with this law? Why not let's just take a pause? Let's take it a step backward. Don't let us be quick to favor the accused. Let's consider the intention of the parliament too. But if after considering the intention of the parliament and trying to read the purpose of the law, you still have some ambiguity, then at that point, the accused person will take the benefit of that ambiguity. That is your purposive interpretation. And I can tell you that when you're interpreting any criminal law, right now in your exams, you would use the purposive interpretation. I'll give you a case example just for this to be clear. And that case NC has given you is the case of Arampare. In Canada, when you commit an assault and it leads to somebody's death, it is classified as first-degree murder, is the law. In this case of Arampare, this guy committed an assault, but the person did not die while he was committing the assault. The person died 2 minutes after he committed the assault. And the court was faced with interpreting that provision. If the court applied the strict interpretation, the strict construction, the one that says that once there's ambiguity, the accused person takes the benefit, it would mean that as a defense counsel, I will go to court and say, Your Honor, my lord, the law says that it is not first-degree murder until and unless the victim died in the course of the assault. My lord, my client committed an assault, but the victim did not die while he was committing the assault. My lord, I beg to disagree with the Crown that this is not a first-degree murder offense. This is simple assault. That would be my argument in court. And that's because I was applying the strict construction, and the court will agree with me applying strict construction. But with the purposive interpretation, what do you think the parliament was trying to achieve when it says that anybody who commits an assault and the victims die in the course of committing an assault, to be counted as first degree murder. What do you think Parliament is trying to achieve? Parliament is trying to prohibit the act of an assault, not just an assault, previous assault that leads to somebody's death. If you commit an assault and somebody dies, my dear, you get first degree murder and you go to jail for more than 20 years or so. Because why? Parliament needs to pass a message across that one, you don't commit an assault. Two, if you do commit an assault, somebody must not die. If somebody dies, you go to jail for a very long time. That's the intention of the Parliament, so that you don't hurt someone so much that they die in the process, right? So in the case of Aram Pare, guess what? The court adopted the purposive interpretation. It says that although the murder did not occur until 2 minutes after, the murder occurred in the course of the same transaction. It was still in the course of the assault, even though it was 2 minutes after. And with that, the accused was convicted or charged to stand to trial for first degree murder. Make sense? You see how purposive interpretation works, and that's how you look at it. Any question on that? In your syllabus as well, you see that there is the French and the English. By the way, do you guys have your syllabus before you as we're doing this? You do? Good. Because if you flip through, you see that there's the French and the English version. It also helped the court to interpret criminal law provisions, right? In Canada, we all know it's bilingual. You know, some parts speak French and some parts speak English. Because of that, all of the laws of Parliament's enactment are written in two versions, the French and the English version. So the court would sometimes consult the other parts to get clarity as to what a particular version is saying. For that, you see the case of Aaron Collins, a very good example, because in that case, section 24(2) that we talked about earlier says that the court was faced with interpreting a particular word in that section. And this provision of that French version was that, I'm summarizing, the evidence would be excluded if established that admitting it could bring disrepute into administration of justice. You see the way they use the word would in the French version. The evidence would be excluded. That's French version. But the English version says the evidence shall be excluded. And the court says that if they used the French version that says would, it will bring the administration of justice into disrepute. Why? Because you should not use would when you've agreed with the accused person that the police had infringed on his right. If it is would, it means that you are saying, oh, you could get remedy or you could not get remedy. The court says that word was not firm enough. The court preferred the word shall in the English version. So that's how the court consults both versions in trying to gain clarity into the mind of the Parliament when they enacted those laws. Make sense? And then, of course, the charter. We already talked about the charter, how the charter sort of influence how statutory provisions are interpreted and all of that. We already talked about that. And that sums up how you interpret your criminal law provisions. That's chapter 3 of your syllabus, right? No, chapter 4. So this is where we go into the major part, which is the elements of a criminal offense or regulatory offense. But let me take a pause here. How are you guys feeling with this so far? You can unmute your mic. I want to hear you. How are you feeling? Let me gauge your pulse. So far, so good?
Yeah.
Good job,
Yes.
sis. Good job. Abigail, how do you feel?
I haven't read any criminal law material yet, but I'm following you. So it's a very good discussion. So thank you.
Very good. B, your turn. How do you feel so far?
I agree with what Abigail said. I haven't exactly read anything, but I've been able to follow so far and make some notes. So it's good.
Very good. Very good. Puneet, do you think you like criminal law? Remember when we started say, oh, I don't like criminal law.
You make it interesting, that's for sure. Maybe if I took your classes, I'll start to like it more.
Yes, you will. You will like it more. Thank you, Puneet. Tolu, how are you feeling so far?
I'm feeling good. I'm tired. Forgive me. I've been awake
I
because
know.
I'm also reading for constitutional law. So
Oh, yeah, I know.
it's a
You
mixed
see,
morning, but so
your real
far so good.
licensing journey, it's tedious, but it's worth it. So
Amen.
do everything you need to do, and you will be good. Trust me. We all went through it. We all went through it. So I know how you guys are feeling right now. But you will be good. You are yet to pass, and pass you shall. Okay, so elements of criminal law offense, the big elephant in the room. It's actually very simple. You know, I'll tell you, when I practiced in Nigeria as a prosecutor, when it came to trying to explain to the court the intention of the accused, I struggled a lot with it. But when I came to Canada, the laws have been drafted in such a way that it's made it easy for me to prove to the court the intention of the accused. And you will see that as we go. So it's very beautiful. You will love it. Now, we have criminal law, we have regulatory offenses. We will take the criminal law first before we take the regulatory part. Remember I said that we have different principles applicable to these two things. So for criminal law, what are we talking about? How can the prosecutor prove beyond reasonable doubt that an accused has committed an offense? It's actually very simple. We all have these two things, actus reus, mens rea. Actus reus meaning the acts, mens rea meaning the intention. These two things must be present at the same time before the prosecutor can say that the accused has committed the offense beyond reasonable doubt. Now, let's start with the actus reus. The actus reus also have its own elements. What must be present before the prosecutor can conclude to the court that the accused committed the acts? One, the act itself must be unlawful. I think that's given. The act itself must be unlawful. It must have been prescribed in a particular law. That's one. The conduct of the accused must have been done willingly and voluntarily. That's true. Now, when we say willingly and voluntarily, don't mistake this for intention. This is focusing on the act, not the intention. And I'll explain what willingly means. I always give this example in class. Let's assume somebody is suffering from seizure, a medical condition where they cannot just control part of their body. They can't control it. It just moves. It just moves on its own. And we know people like that, right? If that kind of a person happened to slap you, Puneet, just comes to you and then the hand just couldn't stop and then just slapped you. The act of slapping you is there, right? But would you say the act was done voluntarily? You would fail to say it was done voluntarily. Why? Because this person was suffering from a medical condition that they could not control their hand. So that particular element of actus reus, that the element of the offense must be voluntary, would have been lost. The Crown would not be able to prove it. And if you're not able to prove any of these things, 1, unlawful act, 2, voluntariness, 3, I'll just list them. 3, consent of the victim. And 4, causation, if applicable. I'll come back to them. If prosecutor failed to prove any of these things, then you cannot say there was actus reus. Does that make sense? Make sense, guys? So if you're not able to prove that the act was done willingly or voluntarily, then there cannot be actus reus. I've explained the unlawful purpose. I've explained willingness and voluntariness. Now I will go to consent. There are 4 things. I hope you guys are taking notes. There are 4 things under actus reus. I've talked about unlawful conduct, unlawfulness, meaning the act must have been prohibited, right? Number 2, the act must have been done willingly or voluntarily. And number 3, consent of the victim. Remember when we talked about the case of R and Jubidon earlier? If the victim consented to the assault, then you cannot have actus reus. Because as the accused person, you simply go to court and say, oh, the victim consented. Now, there is a whole lot of conversation around consent that we'll have in the intensive class. We can't have that right now, right? So, but suffice to say that consent is a very essential element of actus reus, such that if there was consent, there cannot be actus reus. But remember the case of Ara and Jobidon, that if the infliction of harm was grievous, you cannot choose consent as a defense. Remember that one? That one is applicable here right now, right? The fourth one is causation. When you talk about actus reus, your act must have caused something to happen. Causation, right? Just causing something to happen. Now, it is not every offense under the criminal code that require that causation element. It is not all of them. And we will master the act of knowing which one requires causation and which one does not in the class, right? But if you happen to have a law that requires the prosecutor to prove causation, the actus reus will not be complete if the prosecutor has not proven that causation. So the prosecutor must say that the accused did not only do the act, but the act led to a particular thing in happening, causation. The prosecutor must prove that causation. One last thing I'll say about actus reus before I move to mens rea is that the act itself, the general circumstance of the conduct, must be done in the way Tolu is about to swallow the whole class. And she ran away. So the act, the conduct of the accused must be done in the way and circumstances that the parliament envisage in the law. So if the law says somebody must, that the accused must commit the actus reus in XYZ circumstances, the prosecutor must also prove those circumstances. Make sense? Makes sense, right? I'll give you an example before I move. There's the case of R and DJ in your syllabus. What happened in the case of R and DJ? The accused, right, was, it's the case of section 72 of the criminal code. The court was faced with interpreting forcibly entry. If you read that section in the CC, you'll see all of this. Forcible entry under the criminal code. What happened in the case of R and DG? The law is that anybody who forcefully enter a place commits an offense. In the case of R and DG, the accused committed an offense and the police was chasing him, trying to arrest him. And the accused then entered into the house of his friend. And when he entered, he told the friend, oh, pretend I live here, pretend I live here. Remember, the law says anybody who forcibly enter a place commits an offense. The prosecutor or the police charge the accused for forcibly entering a place. So necessarily, they must prove that he forcefully entered that place. Now, that element was missing. Why? Because even though the accused ran into the place, he did not forcefully enter the place. He entered the place because he was familiar with the people living in the house. And when he entered, he told them, pretend I live here. So he did not have to force himself in any way. So in that case, the statutory condition of committing the offense that the law envisaged that the accused must show, or the prosecutor must show, the prosecutor failed in showing that that statutory condition was met. So even though the accused entered the place, he did not forcefully enter the place. So that's an example how your actus reus must meet the statutory conditions that the parliament envisaged. Make sense? And so that's just the example. I'll leave the actus reus at that and move to mens rea, right? For mens rea, what are we talking about mens rea? What is it? Mens rea, okay, before I move to mens rea, I always tell my students to do one thing. When you're trying to understand what actus reus you're trying to figure out in your law, in your criminal law, I always tell them to focus on the verb, the action words. What was the accused person doing in that law? Or in the fact pattern, what did the law say the accused person must do? So just focus on the verb. We'll do the exercise in class where we go through the offenses, some of the offenses in the criminal code, and we'll have to tell ourselves what was the actus reus, what was the mens rea. We always do that exercise in class, so you actually get familiar with that. So now, let's talk about mens rea. Mens rea, while the actus reus is focusing on the act, the mens rea is focusing on the intention. Both the act and the intention must be present at the same time before the crown can get, prove beyond reasonable doubt the commission of the offense. Now, when we talk about the mens rea in Canada, this is what I was saying earlier, that it helped me to understand it more. The Canadian law helped me understand it more, because in Canada, we've divided mens rea into two: subjective mens rea and objective mens rea. Subjective mens rea, just as the name or the word imply, is subjective, is personal. So the subjective mens rea is focusing on the accused's mind himself. No one else's, just the accused. The court will ask, what was the accused person thinking at the time of committing the offense? It is subjective mens rea. I can quickly throw this in, that most capital offenses or most serious offenses require subjective mens rea. I'll just throw that in. The second part of mens rea we have is called the objective mens rea. Objective, just as the name implies as well, it is objective. It is a reasonable man's standard. The court, in applying objective mens rea, is not looking into the mind of the accused, but is asking what a reasonable person in the circumstance of the accused would be thinking at the point of committing the offense. Before I go deeper, why do you think subjective mens rea and objective mens rea is applicable in Canada? For subjective mens rea, it is harder for the prosecutor to prove subjective mens rea. And it is harder because it is applicable to those serious offenses that the accused, when convicted, could go to jail for a longer time, where their liberty is mostly at stake. The court says, you know what? We're just going to do subjective mens rea. I'm not sending this guy to jail until I'm sure that he actually did intend to commit the offense. But for the objective mens rea, it's a little bit laid back. The objective mens rea will be applicable in most minor offenses. It's basically a mens rea that looks into the reasonable man's standard. What does society think about this? Well, how would society feel about it? What's the Tolu, your hand is up.
I'm sorry, just wanted to confirm that when you're saying minor offenses, would that also be the same as summary offenses?
You'll be right, but there is also an explanation I can give for that. So when I say minor offenses, you see those offenses listed under section 553 of the criminal code I mentioned earlier, the theft, obtaining by false pretenses, breach of bail conditions, all of those things. If you read your textbooks, they will tell you that the divide between summary offenses and indictable offenses are not so clear anymore. It's blurred now, because some offenses, even though they are under summary offenses, you cannot really say they are minor offenses, right? So I'm careful answering your question to say that when I say minor offenses, I'm referring to summary offenses. I'm very careful answering it that way. But if you want to take it on the surface, for the purpose of understanding what I'm trying to say, you could shelve it like that to say the minor offenses are summary offenses. Yes, you could. And in the class, we can elaborate more on that. But for this purpose, yes, right? And then I was talking about the objective mens rea. So the objective mens rea, you would find it applicable in offenses that are not capital offenses, offenses that are not listed in section 469. The offenses under section 469 are treason, mutiny, treason, murder, and the likes, all those big guys. So for those offenses, you require subjective mens rea for them, because by all means, you don't want to convict someone unless you're sure that they actually intended to commit that offense. Otherwise, you'll be doing grave injustice, right? Now, for objective mens rea, it looks to the reasonable man's test, the reasonable man's standard, And you find it mostly in the negligence-based offenses. Offenses that the accused was not really bad, but was just negligent. You know, for the offenses that require subjective mens rea, you could say that the accused had an evil mind. Is this making sense at all, guys? I know it gets a bit blurry, but for the subjective mens rea, the one that require the court to look into the mind of the accused, the offenses were so grievous, but at the same time, the accused would have committed the offense in a way that shows their evil mind, that they were just evil. Somebody committing treason, committing murder, those are serious crimes that you cannot get to commit them unless you form the intention that you really want to commit them. So those are evil offenses, evil-minded offenses that the court say, okay, because this guy may go to jail for too long, let's give him a subjective mens rea so that let's be sure that this evil mind of his, he actually had it before we send him off to jail. But for the objective mens rea that is applicable to the negligence-based offenses, for example, somebody does not have an evil mind, but because he was not careful enough, he has committed a crime, and at the same time, he has to be punished for it. So for that, the court is mindful that it is negligence-based because on a good day, the person does not have an evil mind, but because an offense has been committed, there is a victim, injury has been sustained, somebody has to pay for it. So at the same time, you would have to be punished, but the punishment you will get would not be so much compared to this person who committed an offense that requires subjective mens rea like murder. Now, when we go to objective mens rea, I will tell you, and I will quickly cite the case of Aaron Crichton, just so that this point is very clear to you. In Aaron Crichton is the case of the guy that was dealing in drugs with his friends. They were just using drugs, right? And on this particular day, he had used a needle to pass the drug into his friend's body. And in the course, the friend convulsed and died. Now, you all know, or if you don't know, you get to know in class that when you commit an offense that leads to somebody's death, but you did not intend to kill that person, it is called what? Somebody throw it in.
Manslaughter.
Anybody? Manslaughter. It is called, thank you, Sheson. It is called manslaughter. So you did not intend to kill the person, but your conduct or your negligence has led to somebody's death. In that case, you will not be charged for murder, you will be charged for manslaughter. So in Aaron Crichton, this guy was charged for manslaughter. And what the court was faced with is what intention is required. What kind of intention must the crown prove? And the court says that because it is a negligence-based offense, the applicable mens rea will be the objective mens rea. A mens rea that looks into the reasonable man's standard, not looking into the mind of the accused person himself. Reasonably, the society would expect that you would not deal in drugs in such a way that you pass it through somebody's body, and then if the person dies from it, then by all means, even though you did not mean to kill the person, you will still receive the punishment. So we have different categories of negligence. In class, we'll talk about them. We have the simple negligence, we have the penal negligence, we have the criminal negligence. They all have different implications, and they are all contained in the criminal negligence, and the penal negligence are contained in the criminal code. The simple negligence, I will tell you, is for civil action and it's not applicable for the purpose of your criminal law. Okay, so the focus is criminal negligence and penal negligence, right? So for those are the two types of mens rea, subjective and objective. Now, in trying to understand what the mind of the accused is saying, the criminal law in Canada had also been good to now give us examples of what kind of intention an accused can have. For example, you begin to see, let me go to my notes, you begin to see subjective mens rea with objective features. Puneet, I don't like the way your face is looking right now, but I will explain all of these things, trust me. So for subjective mens rea, you want to prove that the accused person had the subjective mens rea to commit an offense, how do you begin to put it out to the judge? What do you need to look out for? How do you tell? Your syllabus says that, for example, knowledge. If you could prove to the court that the accused had the knowledge of a particular incident, then you can begin to show that the accused had the intention to commit the offense. That's one. Number two, willful blindness. I'm sorry, I don't know why I'm sniffing right now. Excuse me. Number two, willful blindness. If you could prove to the court that the accused had knowledge of something and the accused would have known of the existence of a particular situation, but chose not to know, turned a blind eye, just so he could go to court to tell the court, I didn't know. That would be willful blindness, and you can use that to prove his intention, his particular intention, subjective mens rea. That's another instance. Another way you can prove this is, the very first one in your syllabus is the intention, purpose, and willfulness itself. What particular intention did the law require? What intention did the law say the accused person must have? You must show the court that the accused person had that particular intention that Parliament intended. And you will know this from reading the law. That's one way you can tell the subjective mind of the accused as well. There's another one called subjective mens rea with objective features. This one is a bit tricky, but I will tell you, this one has a combination of subjective mens rea and objective mens rea. But I can allay your fears by saying that you will only be faced with this kind of intention when you are dealing with two kinds of offenses. Number one, fraud. Number two, sexual offenses. So when you have the cheats, I always give my students is, when you have a fact pattern surrounding sexual offense or surrounding fraud, just know that the relevant mens rea for that offense is subjective mens rea 1, and the particular subjective mens rea is this one, subjective mens rea with features. And I'll quickly explain what that means. When we talk about subjective mens rea with objective features, right? This one is just trying to acknowledge that there are some offenses or conducts that are also subject to interpretation. The very quick example I give in class is when you commit a sexual assault, and the sexual assault is such that you had touched a part of the body of the victim. So for the Crown to be able to secure conviction, they must prove that you touched the part of the body of the victim without their consent. Does this make sense? Now, the subjective mens rea is saying that the Crown must prove that the accused himself intended to do that, to touch that part of the victim's body or to do whatever to the victim, right? Now, sexual offenses are such that it could be interpreted in different ways. Somebody from a particular culture or from a different culture could go to court to say, oh my Lord, I touched the victim, and I'm sorry for using this word, I touched the victim on her breast, but in my culture, touching somebody on their breast is not a sexual offense. Or in my own understanding, I do not think that touching somebody on their breast will amount to a sexual assault. So the reason why the law has interpreted this to imply subjective mens rea with objective features is that society has a standard. We all understand what sexual assault could mean. We all know that there is this part of our body that is regarded as private, our breast, our boobs, and whatever part the society regards as private, right? My private area is my private area. So the subjective mens rea is that the Crown must prove, one, that the accused intended to touch the victim on that part of their body. That is the subjective mens rea. But the objective mens rea will quickly come in when the court or the law is saying that whatever explanation you have regarding that part of the body as an accused person becomes irrelevant. Meaning at that point, the court is adopting the objective features that society agreed to. So if, for example, somebody has assaulted me, sexual assault, touched my boobs and all of that, and then he goes to court to say, oh, Your Honor, yes, I touched the boobs. That's a subjective mens rea, right? He intended to touch my boobs. That's subjective. He himself did it. He intended to do it. So the first leg of subjective mens rea is proven, right? But then the accused person added that, oh, Your Honor, I touched her boobs, but I do not understand that to mean a sexual assault. The Crown would jump in to say, oh, Your Honor, this offense requires a subjective mens rea with objective features, meaning that as a Crown, all I had to prove to the court is that he touched Idayat or Heidi on her boobs. Whatever explanation he has as an accused person becomes irrelevant because why? The society already agree that touching somebody on their boobs means a sexual assault. So even though the court is mindful to look into the mind of the accused person, he is also mindful to know that the society has a standard of what sexual assault is. So the accused person will not be able to say, I touched her on her boobs, but to my understanding, that is not sexual assault. The court would tell him to keep quiet because this particular offense requires a subjective mens rea with objective features. So we look into your mind, but we also want to be objective about it. Meaning, consider the reasonable person in the society. What does a reasonable man in society consider as sexual assault? That would now come into play. Does this make sense at all, guys? It does? And this kind of mens rea, you only have it in 2 offenses, so your work is easy. The moment you can see fraud fact pattern in your question, you know you are dealing with this kind of mens rea. So it is only with fraud and sexual offenses. So it's easy for you to identify. Does this make sense? And the same explanation goes with the fraud. Somebody has obtained money by false pretense, but is going to court to say, oh, that's not my own definition of fraud. The court will say, no, let's take it one after the other. Did you obtain the money by false pretense? If the answer is yes, leave out your own explanation of what you understand. We know what the society terms as fraud. Does this make sense? Guys? Abigail?
Yes.
Abigail is frozen on my screen. Cheson, I can't see you anymore.
Sorry, my internet connection is poor here, so the video is breaking.
Okay. Does this make sense, guys? So when you're dealing with your trying to identify the mens rea, the first leg of it is what type of mens rea is applicable. Is it subjective mens rea? Is it objective mens rea? Once you take that out of the way, and in class, as a matter of fact, I have a sheet. I've drawn up a step-by-step analysis of how to identify your mens rea. I'll be sharing that with you in my class. So you will be able to identify it, no doubt, right? So once you're able to tell yourself that this is subjective mens rea, this is objective mens rea, then you begin to delve in deeper into them. So for subjective mens rea, which of the applicable forms of mens rea do I have? Can I prove it with knowledge? Can I prove it with recklessness? Can I prove it with willful blindness? Can I prove it with subjective mens rea with subjective features? Can I prove it with intention, purpose, and willfulness? You see, that's how you come up with it. Does this make sense? So when we do go into the intensive class proper, we're going to delve into this one after the other, okay? For now, I think I'm not able to proceed further because it's been 2 hours and my kids are knocking my door because we actually have a lunch date. So even though I want to stay, but I cannot, my kids won't let me. But do you guys have any questions? Abigail is frozen on my screen. Okay, yeah, she's back now. Do you guys have any questions? How are you guys feeling so far?
It gets funny a bit.
I know. It's an introductory class, so don't be hard on yourself. I'm not expecting you to, take 100% of everything now, because I'm just introducing the course. But I want to put you in the spirit to be able to read. And when you read, I want you to find it interesting. And I want you to just keep turning your paper when you read. So that's the purpose of this class. It's not for you to grab everything, right? So I think I should leave you guys now. I'll leave you with my email address, which is idayat @ncaguides.com. The intensive class is going to start in 2 weeks. We're going to have 5 classes of 3 hours each. We're going to have an exam workshop where we actually tell you how to answer these questions. And in the 3 hours classes, I'm going to be sharing with you my summary notes. I'm going to share with you my fact sheet on how to identify your accessory assignments here. I'm going to share with you chapter by chapter summary of my notes of the textbook, summary note of the textbooks. And I can tell you again, like I've said before, that I have recorded 100% pass rate. None of my students had failed criminal law with me, even those that had done it before meeting me and had failed many times. And somebody had told them, oh, go to Idayat, and they've come to me on their 3rd attempt with fear. They still passed it. So to that extent, I tell you that you are with the right person, because I bring to you my experience as a defense counsel and as a crown prosecutor. So you get the best from me, okay? I wish you all the best. If you do decide to register, I implore you to do so ASAP. If you do not want to register, know that you can attend the exam review workshop, of which you pay for, and you can also buy the answer framework on the website. But if you register for the classes, your exam review workshop is free, and you get a discount on the answer framework. So I'll leave you now, and I wish you all the best. You can email me if you have any questions for me. This video recording will be posted on our YouTube, so if you missed a part of it, you can always go back to it. Thank you very much for coming here today, and I will say bye for now, unless you have something to say.
Thank you very much.
Thank you. That was B. Hi, Puneet. Bye. Bye, guys. Chesson, see you
very
guys.
much.
Bye-bye.
We are NCA's guide.
Every year, a significant number of foreign-trained lawyers immigrate to Canada, and hundreds of Canadian citizens return to Canada after obtaining law degrees abroad.
Upon returning to Canada, they have to get their credentials assessed by the NCAs and write several equivalency exams before being eligible to be admitted to any of the respective provincial bars.
The NCA exams are examinations very similar to those taken in the Canadian law schools. They're fact-based and open book examinations that take 4 hours to write. They're currently administered online.
These exams, which are graded on a pass or fail basis, are done without any help of the NCA. This is where we come in.
I have written and passed the Canadian Administrative Law exams.
I have taken and passed the Canadian Professional Responsibility examinations.
I have written and passed the Canadian Criminal Law examinations.
I have written and passed the Canadian Constitutional Law examination.
I have written and passed the Foundations of Canadian Law examination. We have all been through these examinations. We understand the difficulty that the NCA examinations present, and we help candidates overcome these difficulties and obstacles in understanding the course materials and the exam formats.
We do this through intensive classes, revisions, spot tests, and exam review workshops. We do not believe in a one-size-fits-all approach. Our study sessions are focused on helping candidates understand the course materials in a way unique and personal to achieving their study goals.
We have a great track record and excellent results from our past and present candidates. If you're writing the NCA exams and you want to pass them all at your first attempt, join our classes today.